are you? And where are you going? What do you want?
Hello and welcome to Trusts and Estates Weekly. I'm your host, Kevin Bemmel, and we're here every Monday at 10 a.m. Pacific time to talk about all of those matters related to estate planning and trust and estate administration, both from your personal needs and also for professionals like myself who help people with handling their trust and estate situations, their estate planning. So today I'm going to talk about a subject that has long been a part of my professional career. So most of you who have watched the show know that before becoming a professional fiduciary, an independent trustee, I was in the Navy. Prior to that, I had a real estate services company here in Los Angeles for 20 years. And one of the services that we provided the entire time I had that company was property management and some asset management as well. And so, and one of my primary clients during that time was Jewish Family Services conservatorship program. So I was involved with a lot of estate matters and conservatorship matters, the same kind of thing that I do as an independent trustee and probate administrator. So and currently in one of the estates that I'm administrating, there is a real estate services company very similar to the one I had before I joined the Navy, and I administrate that company as one of the assets of the estate. So it's been interesting to be sort of back involved in that world. Tangentially, I don't work for the company. I administrate it as an asset. And so what I want to talk about today are the unique is maybe too strong a word, but managing a property that's going through probate is different than managing a property that is not going through probate. So those are two different animals. And I think it's valuable if you're a property owner to understand what some of those differences are. And if you are a fiduciary or a lawyer or accountant who deals with estates, or for that matter, if you are in the real estate business, it's good to know what are the special concerns with which you're going to have to deal when you're managing a property that is going through probate. It is by no means the same situation as just handling a property. So I made a list of 7, and I think these cover pretty thoroughly the various issues that you need to take into account. So first of all, right off the top, if you're going to manage a property that's going through probate, the first thing you need to do is confirm that indeed the deceased owned the property and that there are no other claims existing against the property. So I'll give you an example of where this could come into play. I've been nominated to be the administrator of an estate that owns it's really just a single family residence, a house. Partway through the nomination process, all of a sudden a supposed trust appeared that owned half the house. And the trustee of that trust was, he happened to have died recently, was the grantor's ex-husband, right? And the grantor, I won't get into the details, but if you were going to be taking that property on to manage it, especially in this interim period. So there's a question: who owns that house? The matter is slowly making its way through the courts, and it's not at all clear which way this is going to work out. Now, like so many of these cases where there's a dispute, an awful lot of time and money is being spent on the various sides, claiming that they're right and the other side is wrong. My attitude is, look, it's a house. There are only one or two beneficiaries, whatever it is. At this point, why are you wasting money fighting? But people love to fight. So, but in any event, if you were going to take on the management of that property, it would be unclear who has the authority to contract you to do so. And whereas if, let's say the trustee under the trust contracted you, you might say, well, that's solid because the trust doesn't need court approval and all of that. Well, under normal circumstances, yes, that's true. But in this case, there's been a challenge to the validity of the trust, and you could do an awful lot of work and end up finding out that since the trust hired you, and if the court were to decide that the trust in fact never owned the property, the trust was invalid, if you'd been paid, the court could require you to essentially disgorge those payments. If you hadn't been paid, it's unlikely that you would get paid. Well, I don't want to say unlikely. There's a chance that you would be denied payment. And worse if you had advanced monies. So I have another administration where in this case, it was the previous administrator advanced money to pay property taxes and all kinds of things. And then the will under which she was appointed was declared a fraud by the court. And now she's applying to get all kinds of reimbursements. It's not clear that the court is going to order those reimbursements. The court may decide that she was a party to the fraud, in which case it would deny reimbursements. So when you're going to handle real estate, you first and foremost, you need to deal with title and ownership issues and make sure that the person who is contracting you has the authority. That the owner of the property, that the deceased owned the property, and that there aren't now competing claims for ownership of the property. Okay, and closely associated with that is, do you need court approval, and who has the authority to administrate the property? So, pardon me, just because someone is named as an executor in a will, that does not give them authority to administrate the property prior to the court granting a petition for them to administrate the property and issuing letters of administration. That's what they're called here in California. In Alabama, for example, they're called letters testamentary. But in essence, it's the issuance of the letters, whether to an executor or to an administrator, or what's sometimes called a personal representative, encompasses both categories. Until those letters are what gives the personal representative the authority to act on behalf of the estate. So even if it's clear that the decedent owned the property and now the property is held by the estate and there's no contest to that ownership, nonetheless, the executor or administrator does not have the authority to hire someone to manage that property until the letters are issued. Okay. And that, in fact, the administrator has no decision-making authority prior to issuance of the letter. Now, things can be done to prepare for when the letters are issued. Okay, so for example, the administrator may have the petition for administration may have been granted. Okay, and that would be a matter of public record. You could, if your court, if your jurisdiction has an online portal for the court, you'd be able to find that order. And it may just be a matter of the administrator having to post bond and the lawyer having to submit the letters, and then the court signs them and issues them. Okay, so once the order has been, once the petition, has been granted, so the personal representative, the administrator, may say, "Hey, please send me a management agreement, and I'll go ahead and review it in advance. That way, once I have the letters, I can go ahead and the agreement can already be worked out. I can sign it immediately, and we can get going." By the way, the same would be true of listing the property for sale. Until letters have been issued, the administrator does not have authority to list the property, to sign a listing agreement, which is listing the property. However, he can review a listing agreement, get any questions answered, all of that. So there's nothing wrong with doing advance work. Just understand that there can always be last minute challenges. And so you could draft that property management agreement, that listing agreement, and after the court has granted a petition, and at the 11th hour and 59th minute, as they say, something could happen that would cause the court to not issue letters pending the resolution of some kind of dispute. So, for example, let's say that the decedent appears to have died intestate. Okay, and then after the petition for administration is granted, a will pops up. Okay, and that will may have heirs in it that are different than who would inherit the assets of the estate intestate. Okay, so they may challenge the appointment of the administrator for various reasons. Okay, especially if there is bad blood between the intestate heirs and heirs that would only qualify because there's a will. There may be a lack of trust. All kinds of things come up. You really see a proctologist's view of life when you work in this area. And so just know, if you are going to do like draft an agreement in advance, don't be counting your chickens before they hatch, as they say. Until those letters are issued, the agreement cannot be signed. Okay, the other thing is also you need to know what authority the personal representative has. So a personal representative can have full authority, which means basically they can do anything that needs to be done to administrate the estate, generally speaking, without court approval or confirmation. And they might have limited authority. So they might have been appointed as a special administrator, for example, who for sure would have limited authority. Or they might be appointed as administrator, but with limited authority. So, for example, they may not have authority to sell property or to mortgage property, those kind of things, without the court's approval. Okay, so if they're going to sell a property, they can list it. Okay, but they're going to have to apply to the court to confirm or approve the sale once a buyer is found. Okay, now, when it comes to engaging a property manager, so typically, even under limited authority, the administrator would have that, but you just never know. So it's always a good idea, if you're going to be dealing with real estate, to get a copy of the letters of administration or the letters testamentary, and see what authority does the administrator have. I wouldn't take that for granted. Okay. Right. So court approval, the extent of the authority of the personal representative, that's another aspect of managing property in probate that's different than managing property that is not going through probate. Okay, next I mentioned heirs or beneficiaries. So while generally speaking, the administration of an estate is done for the benefit of the heirs and or beneficiaries, hence the term beneficiaries, okay? That does not give heirs or beneficiaries any authority to make decisions or dictate decisions, okay? So you might get a call from somebody saying, "Hey, my father passed away last month, and he owns this apartment building, and I need someone to manage the apartment building." You say, "Oh, okay. Well, so it was your father who passed away? Yes. So then you're an heir? Yes, and that's according to a will? Yes. Okay. Right. And are you the executor of the estate? No. Okay, well, right then and there, you know that you're not talking with someone who has the authority to engage you. Okay, so you can say to the heir, well, if you'd like to refer me to the executor or to the administrator, I'm happy to talk with him about taking on the management of this property. But unfortunately, um, if you're not the executor or the administrator, the personal representative, you don't have the authority to contract me to manage the property, and so for me to be handling the property under those circumstances would be wrong, or however you want to phrase that. Okay, and I would say I would be careful with these kind of things because it's not unusual for heirs and beneficiaries to try and usurp authority, uh, and get a hold of the proceeds that otherwise should be going to the estate and take them directly themselves. Again, I'm dealing with a situation where the one I mentioned a few minutes ago. That it took 3 years for this will to be declared fraudulent. In the meantime, it appears that the heirs to the estate or the beneficiaries basically, took all of the money in bank accounts and that kind of stuff. Okay, and that's prejudicial to it was an entity fighting to prove that the will was fraudulent because they're owed a tremendous amount of money. And so now, some of the it may be, I can't say for sure. I'm just starting this, but it may be that some of the assets of the estate were taken essentially under false pretenses and now are not there to settle the debt. Okay, so again, some skepticism is worthwhile. I would also say that if you have been correctly employed or contracted by the personal representative of the estate to manage the property or list the property. So your communication should be with the personal representative, not the heirs. If the heirs contact you and want information, unless you have been specifically directed by the personal representative to give a specific individual information, and by the way, I would get that authorization in writing, you should only be communicating with the personal representative who then can deal with the heirs and the beneficiaries if necessary and as needed. That's really within the scope of duties of the administrator. Okay, so you don't want to usurp the administrator's role. You don't want to overstep the boundaries. And the fact of the matter is, you may have the best of intentions in passing along information, but in doing so, you might inadvertently cause a dispute to arise, and now there's a problem that could delay the closing of the probate, or it could cost money to resolve, et cetera, et cetera. Okay. Next, ongoing expenses and maintenance. So, in general, now, assuming now that you have the authority from the duly lettered administrator to manage the property, okay? So, your duty is to then perform all of the things that are competent property manager would do. So pay property taxes, take care of any loans, insurance, utility bills, all should be kept current. Now, if it's a income producing property, presumably there will be funds to pay for those things. If there is not, then before taking on the management of that property, it would be wise to inquire. Let's say you've been asked to manage a single family residence that's vacant, okay, and the administrator wants someone to make sure that the landscape is maintained, and whatever needs to be done in the house is taken care of, whatever. Okay, so it would be wise to inquire, how will those items be paid for, since the property is producing no income? Okay, because again, if you advance those monies, okay, while you will have a claim against the probate, that claim is not necessarily automatic, and so you may have to file a claim in probate in order to get those costs reimbursed. So I would clarify that and make it part of your agreement how funds either advanced are going to be reimbursed, or how funds necessary for managing the property, maintaining the property, are where they're going to come from. Okay, now one of the advantages, if you will, of being in probate is, let's say there are no funds to pay the loan. Okay, there, for whatever reason, there's no liquid assets. Okay, and since there's no liquid assets, and just because you've been hired to manage the property doesn't mean that you're required to advance those funds. If the lender chose to foreclose, okay, then the administrator, and again, it wouldn't be you, but it would be, you'd be advising the administrator, hey, here's, we got a notice of default, so then it would be his responsibility to petition the court for not a forbearance, to basically for an order stopping the foreclosure. Okay, now perhaps a forbearance could be negotiated with the lender, but and you may be a part of that. Okay, but if you are going to do something like that, the authority to do that doesn't come from you per se. It's the administrator who has the authority. Okay, and this goes back to what I was talking about a little while ago. So what is the extent of the personal representative's authority? Does he have does he have the authority to negotiate with an existing lender for some kind of forbearance agreement, or to renegotiate terms of a loan, those kind of things? Okay, if he does, then he can delegate that authority to you. Okay, and then dos vidania, as we say. Although if a forbearance agreement is going to be entered into, it's probably not something as a property manager you would want to sign. The personal representative would be the correct person to sign it. Okay, but in any event, the probate court can stop a foreclosure. Okay, it can also, I believe, stop a property tax sale. So I mean, it would be presumably a long probate where you would get to the point where the tax assessor was actually going to sell a property for unpaid property taxes. I think here in California, it's 4 or 5 years, but it's not outside of the realm of possibility. And if look, this case that I mentioned, I'm using this case a lot because it's such an unusual case. It took 3 years for the will to be declared a fraud by the court. If the property taxes had been unpaid for that entire 3-year period, another year or two, it's possible that the tax assessor might try and sell the property for back property taxes. Okay, so presumably, if that were the case, I would, I would go to the court and I would petition the court to essentially prevent the tax sale, with the understanding that once the property was sold, the property taxes would be paid, and they would have to be before the new buyer would take ownership of the property, because they're not going to take ownership subject to the shouldn't say not, but it's unlikely they would take ownership of the property subject to that lien for unpaid taxes. Okay, other things that are unusual from an ongoing operations and expense perspective in a probate are the death of the owner may give the lender the right to call the loan. So I've got a case like that right now, where when the lender was notified that the owner had died, they decided to call the loan. Now, I mean, I think it was a foolish decision on their part, especially because they refused to accept payment while we're in the process, payments, I should say, while we're in the process of refinancing the loan. But that's what they chose to do. Why did they choose to do it? Well, they had the authority, according to the loan documents, to do so, and the interest rate on the loan was pretty low. So I think they were thinking, well, we'll call the loan, we'll get the money back, and then we'll turn around and lend the money out at a higher interest rate. In the event, it's been almost a year. They've gotten no payments. Now, eventually they will, get their back interest or whatever. But that'll all be subject to the court if they try and gouge the estate. So unfortunately, I mean, my perspective, they made a bad decision. They should have either just let the loan continue, or they should have done some kind of forbearance agreement or something like that. But they didn't do that. However, they had the right to do so under their loan documents, and so they did. So again, that's a different situation than you would find in just the typical managing of a property for a live owner. While the lender has reasons why it can call the debt, generally those have to do with non-payment of loan payments, non-payment of property taxes, the property not being insured, those kinds of things. So this is an added issue when you're dealing with property of a deceased owner that's going through probate. Okay, and then the fourth thing about ongoing operations of a property is it is important that routine maintenance and repairs and security be looked after. It is not uncommon for example, squatters to take up residence in a vacant property, and if a property is going through probate and it wasn't occupied, and maybe the decedent lived there, and so now nobody's living there, or maybe it wasn't occupied at the time of the owner's death, he lived somewhere else. So people look for these opportunities, especially here in a state like California, where squatters can accrue what amounts to a lot of seeming rights to be in the property, even though they came into possession through trespassing. Okay, so you're going to need to be diligent about this, and make sure that the property is inspected regularly, and that no one is on the premises who is not supposed to be, etc. So all of those play into the ongoing operations, maintenance, and expenses for the property. Okay, so I'm going to just take a break here for a minute, and that is I'm trying to remember to do this more regularly. I want to tell you about the LinkedIn group that I started a while back. It's called Trusts and Estate Experts, and it's a forum that you can join where you can ask questions about estate planning and trust and probate administration, and also interact with professionals who, like me, who do this for a living. So if you're a lawyer and you have an accounting question, there's accountants in the group, and you can say, hey, how do you see an issue like this handled? Right? It's all a matter of professional courtesy. So nobody has to pay for advice, but we all kind of work together to help each other out and to make our practices go more smoothly, to do a better job for our clients. That's the intent of the group. So again, it's called Trusts and Estate Experts. It's on LinkedIn. Just search that name and you will find the group, and click the little button asking to be admitted, and I will be happy to admit you. Also, if you produce content on estate planning and trust and probate administration, this is an ideal place to get additional additional exposure for that content. Okay, so for example, my friend Lori Israel, who's an expert on prenuptial agreements, which can be an aspect of estate planning. If you join the group, you'll see her posts from time to time, and there's a couple of other people who post from time to time relevant content. I screen it all, but I will tell you that these are all highly competent professionals looking. This isn't people saying, hey, give me business. Not at all. It's people who are sincerely interested in helping colleagues better serve their clients and become more knowledgeable. So again, one last time, the name of the group is Trusts and Estate Experts, and I encourage you to go on LinkedIn and join the group. Okay, so going back to the subject for the show, this is Trusts and Estates Weekly. Can you see the theme here? And we're talking about managing property in probate, the special issues that one has to deal with when handling a property that is in probate. So far I've talked about title and ownership issues, court approval, and the authority, and who has the authority to hire someone to manage property. We've talked about heirs and beneficiaries, and we've talked about ongoing operations, maintenance, and expenses for the property. Okay, next is insurance considerations. So the insurance company for a property should be notified that the owner has passed away, and arrangements need to be made to ensure coverage. Now, in some cases, and I had this situation when I administrated this. In this case, it was actually a trust in Alabama, when the last of the two grantors died. I'm talking about my dear Marie, who I always salute at the end of the show. So when she passed away, she had been living in the house owned by the trust, and now the house was vacant. And so I notified the insurance company, and they let me know that the insurance would stay in force until the current term was up. But unless the property were occupied, at that point, the policy would cancel, because the current insurance company did not insure vacant single-family residences. Okay. So, and in the event, I did have to find a different insurance carrier. Now, because Marie had been a long, and her husband Jack, because they had been long-time clients of this particular insurance brokerage. They worked with me because it wasn't particularly easy to find a new insurance carrier, and so they actually got me a little bit of extra time with the current carrier while I got the policy in place. And so I would encourage you, work with, in the case of insurance, work with, the people who, the brokers or whoever that currently handle the policy. Okay. Insurance is a very difficult issue to deal with in the real estate markets these days. And uh, um, uh, you want everybody on your side. I'll put it to you that way. You want everybody on your side. And in my experience, most insurance brokers want to do a good job. They want to help their clients out. But here in California, there have been several insurers that pulled out of the market, and there wasn't anything the broker was going to do that was going to reverse that decision. So the best that they could do is help a customer over a difficult time. So work with them. There are some insurance brokers that they represent just a single carrier, like if they represent State Farm or Farmers, something like that. There are other insurance brokers who represent multiple lines, and so if the current insurance company is going to cancel for some reason, that broker may be able to find coverage with another carrier. And since they already insure the property, they know the various issues, and so they may very well be the best insurance broker to use. Okay, and you may say, well, if there's problems, wouldn't I be better using a broker that doesn't know about the problems? Well, maybe, but if you hide problems from an insurance company and then you have to file a claim and they find out that you hid the problems, they may deny coverage, and now you've got a mess. So oftentimes it's best to, as they say, dance with the guy that brung you, I think it is. So be aware of the insurance issues if you're going to be managing a property that's in probate. Okay, especially if there's a change in occupancy as a result. And by the way, if it's a house and the owner dies, and now the plan is to, let's say, rent out the house. Okay, so whereas if the owner were still alive, the insurance coverage might be able to continue even with a tenant occupying the property. If the owner has died, the insurance company may not continue coverage because it's a different kind of risk to rent a property to a tenant than it is to the owner. So again, all of this needs to be dealt with candidly with the insurance company or the insurance broker representing it. Okay, that segues into tenant or occupant issues. Okay, so if the property is a single family residence where the decedent lived, now the decedent is dead, right? And now the property is vacant. Okay, so that kind of gives you that is what it is, right? Now, there may have been multiple occupants of the property, and now the owner, the is the decedent, he's dead, and left behind somebody who's not an owner, and in fact may not even be an heir, or may be an heir, but there are other heirs. So now the occupant of the property could be sort of grounds, if you will, for a dispute. Okay, so it would not be wise to assume that someone on the premises either has a right to be on the premises, or is an heir, or is a beneficiary. I would not make any of those assumptions. All of that needs to be figured out. So I'm dealing with a case right now where the owner of a property has died, left behind his partner, and the partner has no legal standing at all in terms of being an heir. Okay, but he's trying to essentially get ownership of the house. In the meantime, he lives in the house. Okay, so uh, this is a difficult situation because some of the heirs want him there only as a foil to the other heirs, and the other heirs are saying he's not permitted to be there. He's not permitted to profit off the estate in this way. He either needs to pay rent or get out, right? And in the meantime, we're working to get an administrator appointed, right? And so the occupancy issues loom large. One could make the argument it's better for somebody to be there rather than for the property to be vacant and subject to potentially squatters. On the other hand, we don't know what the current occupant is doing. He could be taking things out of the house and sort of squirreling them away where whoever is appointed to administrate the estate won't be able to find them, right? So they're all difficult situations, but they are aspects of what happens when a property is going through probate. Okay, so if it's some kind of income property, okay, and there are leases, rental agreements, whatever, so okay, the leases are going to continue. If the property was owned by the individual directly, okay, so let's say I own a property. Let's say I own an apartment building and it's owned in the name of Kevin Bemmel. Okay, I'm not advising that, by the way. I'm just using this as an example. So then, when I die, the owner of the property will become the estate of Kevin Bemmel. Okay, and notification should be given to the tenants. Okay, and in the future, the tenants should be paying their rent checks to the estate of Kevin Bemmel, okay, as opposed to Kevin Bemmel, right? So, excuse me. But that's fairly easily taken care of. You just notice the tenants. This is to notify you that the owner of the property has died, and in the future, rent payments should be made in the name of the estate of the owner's name. Now, again, you do until an administrator is appointed. No one has the authority to do such things. Okay, so if you're a property manager, pardon me, if you're a property manager, you only would have authority to do that if it was delegated to you by the personal representative. Okay, but that is what you do. Now, if the property is owned by an entity that's now that was owned by the decedent, so let's say the property was owned by ABC LLC, and ABC LLC was a single member LLC, and the decedent was the single member. Okay, so now the estate becomes the single member of that LLC. But from the tenant's standpoint, there's been no change of ownership because ABC LLC is still the owner of the property, and they'll continue to make their rent payments to ABC LLC, presumably. Okay, now if there are family members or other occupants, and this is kind of what I was alluding to a minute ago, so we can't assume they have any particular rights. All of that has to be figured out. There may need to be some petitions made to the court by the administrator, various things. So all of that needs to be worked out. By the way, I have a case, or not a case. I have an estate where there is an occupant of the owner's personal residence. His longtime girlfriend, and he had told her, I guess, prior to dying, that if he were to pass away, she could live in the house for the rest of her life. There's no documentation for that. And he died intestate, no will, no trust, no nothing. Okay. And so it was, it's kind of at my discretion as to what to do about that. Now, the decision I make has to be it has to be for the benefit of the estate and eventually the heir to the estate. Okay. But um, one doesn't necessarily have to be solely focused on finances. However, if an administrator is going to do something that doesn't appear to be for the financial benefit of the estate, that is probably something that should be petitioned to the court, to make sure that down the road the court doesn't come back and say, well, why did you do that? The estate lost money and blah 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 blah. Okay. And so rather than just just because something doesn't just because an administrator has the authority to make a decision without the court's concurrence doesn't mean that the administrator has to make that decision. The administrator always has the option to apply to the court for confirmation of a decision. Okay. And in some cases, that may be the prudent thing to do. So if you are managing a property in probate and there's an issue like that, that is, something to talk over with the administrator, and for you, it could be for your benefit as well as the administrator's benefit to see to it that the court confirms or approves of a particular decision, especially if it deals with family members, potential heirs, etc. If there's a likelihood of a dispute arising, that's something that might very well be a very good idea. Okay, and then finally, I've been talking mostly about kind of ongoing management, but of course, managing property in probate could also mean selling a property, and in that case, if the property is owned directly by the estate, so then you would be hired by the estate to represent it in the sale of a property. There'd be a listing agreement. Okay, now if the property is owned by an entity like an LLC, it's the LLC that would hire you. Okay, but nonetheless, probably the administrator is the one who has the authority to act on behalf of the LLC. Not necessarily, but probably. Again, all of that, those are legal issues that need to be clarified to make sure that whoever is signing the listing agreement has the authority to do so. Okay, so there are a number of issues that make selling a property in probate different from selling a property just normally. And I'm not going to go into the details of that. What I am going to do is suggest that you check out my very long-standing and close friend Bill Gross's show, Probate Weekly. Bill is one of the, if not the most knowledgeable probate real estate agent in California, and he goes into a lot of depth on the special issues that arise when selling a property from probate. Suffice it to say that, unfortunately, one of the difficulties that arises is agents who don't have the knowledge and experience to deal in probate will take a listing and then botch the sale, and it causes problems. So it is a specialty. It's one that requires a great deal of knowledge. And by the way, if you're a real estate agent and want to learn how to do this, there is no one better than my friend Bill Gross at helping you learn that. And that is one of the things he does with his show Probate Weekly, is he helps other real estate agents learn how to handle property sales from probate. So I'll put a link to Bill's show in the notes to this episode when it posts, and I encourage you to check that out. So suffice it to say, managing property in managing real estate in probate is significantly more complex. There's a lot more legal issues to be dealt with. And if you don't have experience in doing this, but you want to get into it, I would recommend that you search out some sources you would search out sources to learn about the probate process, learn about real estate going through probate. Make sure that you have a lawyer who knows the process well and who can advise you when you have questions. Get to know some professional fiduciaries like me who routinely handle these kind of matters and may be interested in helping you learn. Okay. The one thing I would urge you not to do is to just take one on and kind of go on a bender and I'll figure it out as I go. There's a lot of pitfalls into which you can fall, and you can cause a lot of difficulty for yourself, not to mention the estate itself. So if you have any questions, comments, good or bad, please do post them in my social media. All the links will be in the show notes. I welcome them. And as well, my email address will be there. So if you've got something of a private nature, you can always email me. I work to remember to give the caveat. I only will respond to questions that are within my area of expertise. So if it's a legal question or an accounting question, I am neither a lawyer nor an accountant, so I'm not going to give you legal and accounting advice, but I will be happy to refer you to someone who can if you would like. Okay, so tomorrow at 10 a.m. Pacific time is my show, Business Lessons from the Military. I'm going to be talking about the Monitor, the USS Monitor, the first ironclad warship, basically ever purpose-built ironclad warship to go into battle. And we're going to be talking about the lessons of innovation that we can learn from that. And then on Wednesday at 10 a.m. Pacific time is my show, People Making Money. And my guest is my friend Tom Cairns. And Tom is going to talk about of how to avoid getting scammed. So this is a presentation that Tom gives periodically, and we were talking about it a few months ago, and he agreed to come on the show. There are so many financial scams out there. I think you will you'll be very glad to have Tom's information. And then on Thursday is my every other week show, Jiggers' Place. We're going to sit back and have a cocktail. We're going to have the Federalist cocktail, and we're going to be talking about the Federalist Papers. So there's a lot of talk going on the last few months. What's constitutional? What's not constitutional? And one of the best places to go to figure that out is the Federalist Papers, which were written at the time that the U.S. Constitution was going through the ratification process. And it explained what the Constitution was all about. So we're going to have a topic like that is best over a cocktail. So if you're interested in getting the cocktail recipes in advance of the show, please sign up for my email on my email list, and then you will get an email in the morning prior to the show, and you can mix the cocktail with me at the beginning of each episode of Jiggers' Place every other week, Thursday at 5 p.m. Pacific time. So thank you so much for joining me, especially those of you who are on the show live with me. Always a pleasure to see you. Lamon, good to see you, my friend. And hope you have a wonderful rest of the day. And signing off as I always do, Marie, darling, you are my bell.